Welcome you all to the lecture series on corporate law. The present lecture I will be discussing on the importance of the independent directors, the very concept of the independent directors, their functions, role, appointment, as well as the liability of the independent directors. I would also throw some light with regard to the concepts of the key managerial persons as well as officer in default. There are various misconceptions where it says that independent director is an independent person, therefore he is not liable like any other director. However, I try to analyze the existing legal provisions, the existing legal status about their liability, about their role and status in the context of interpretation of the provisions of law, as well as with regard to the development of the importance of independent directors in the Indian corporate law, and why this concept has been evolved and how far this has becoming as the very important. Now let us move on to the provisions of Companies Act. According to the section 149 of the Companies Act, a company to have board of directors, and this we have already discussed elaborately in the previous class, that is called the 3-2-1, that is minimum number of directors to the public company are 3 and private limited company 2 and one person company 1. Now when you see the section 149 clause number 4, right, section 149 clause number 4 specifies in a way that every listed public company shall have 1/3 of the total number of directors as independent directors, and the central government may prescribe the minimum independent of directors in the case of class and classes of the public listed companies. So the reference of the independent directors are given under the section 149 clause number 4. It applies to the listed public companies and not all the companies. I will repeat again. The application of the provisions of independent director applies to the companies, those in the nature of listed public company, and among the directors, the 1/3 of the director should be independent director, and the central government is also given certain powers that the as far as the number of directors depending upon the class and classes of the public companies. So kindly remember 1/3. So if there are a listed public company, if there are 3 directors, so 1/3 of the 3 we have the 1 who becomes as the independent directors. Now let us see what is the nature of the independent director. Who can become the independent director? I will try to throw some light under the provisions of Companies Act, particularly section 149 clause number 6. Under section 149 clause number 6, an independent director in relation to a company means a director other than managing director or whole-time director or the nominee director, and in the opinion of the board, right, in the opinion of the board, he is the person of integrity possessing of the relevant experience as well as expertise. So a person is the one who has qualities of integrity, expertise, and experience. So it is given one way, almost all the discretionary power to the board of directors to identify the persons of integrity that who have an expertise and experience in the relevant field, appoint them as the independent directors. We will see in the furtherance of lectures, in the furtherance of this particular discussion, how to identify independent director, where you will find about the availability of independent director. Say for example, if there is a company which is public listed company, whether it has to put the notice or advertisement in the newspaper, or it has to apply for the SEBI, or it has to go some other central government bodies that we want independent directors. In a simple terms, the method, the manner, and the procedure for the selection of independent director also we will see. And the section 149 clause number 6, there are some other provisions which say that who cannot be an independent directors. These are the clauses which says that a person, if he is related to or if he is coming under the provisions which are stated in 149 clause number 6, they are being disqualified to be the independent directors. Let me tell you one way. If a person who is not disqualified, then he becomes a qualified to be the directors. A person who is disqualified by virtue of the provisions of 149 clause number 6 is not qualified to be a director. I will see what are the provisions which are there under the section 149 clause number 6. So point number 1, he should not be related to the promoters or the promoter group of companies. I will write it in a simple terminology. So promoter groups and promoter group of companies. And C, with regard to the pecuniary relationships, and he should not have the conflict of interest, right? A financial interest. A person should not be related to any group companies, and he should not have any pecuniary relationships, and he should not have any conflict of interest, where if the case some of their relatives are being part of the company, and he neither himself nor any of his relatives hold or has held the position of key managerial persons. We will discuss who is a key managerial person also. Say for example, if Mr. A should be appointed as independent director, if B is the part of the KMP, then A is being disqualified, right? So that's what they brought it a clause here. The person who is related to the KMP is disqualified to be the independent directors. KMP has been defined. We will be discussing very soon who is the KMP. So a person should not be connected to the KMP or the managerial persons, and thereafter he should not be a relative who is an employee. And subclause number 2 of the proviso who says he is or has been an employer, proprietor, partner in any of 3 financial years immediately preceding the which is proposed to be appointed. So that means the person is going to appointed in 2022 as independent director. 3 preceding years means 2021, 2020 and 2019. You should not be related to the company as a partner, as an employee or a proprietary. Or to put it in simple terms, an employee who is in a company, once he comes out as an employee, once this relation is not an employee and employee, he cannot be immediately appointed as the independent director of the companies, right? So if there is an employee who has left the job, then he cannot be immediately appointed as an independent director. That the person can be appointed as an independent director after completion of 3 financial years. That's what the subclause says. Then any legal or consulting firm or transaction. So basically this comes a broader terminology called, one is called related party, the other one is called about the conflict of interest. So where you find the people having the conflict of interest or a related parties with the company, having either directly or indirectly some pecuniary relationships, some control over the management of the company, they are being prohibited, they are being disqualified to become the independent directors of the companies. And subclause number 7, which says every independent director at the first meeting has to declare, right? Has to declare about this status, and the declaration should be provided under the subclause. So if a person is appointed as independent director, then independent director has to make a declaration that he should not have any connectivity, or the declaration as for the procedures and as for the statements given under the Companies Act. Subclause number 8, the company and independent director shall be abide by the schedule number 4. So section 149 has to be read with the schedule number 4 of the Act, where it provides schedule number 4 is code of conduct for the independent directors. We will see the code of conduct in the next slide. And the term of ID. So say 149 says the term of the ID means how many years the independent director can hold the post once he is being appointed. According to the section 149 clause number 11, no independent director shall hold office more than 2 consecutive terms, and he can also appointed eligible, right? He is also eligible for appointment after expiration of 3 years of ceasing to become an independent director. So initially ID is appointed for 5 years plus 5, the maximum is 10 years. Provided that independent director shall not, during the said period of 3 years, be associated in the company in any other capacity, either directly or indirectly. And explanation for this subclause number 10 and 11, any tenure of independent director on the date of the commencement of this Act shall not be counted as a term. So you can try to remember in a simple term, the term of the independent director is for 2 terms, so where he can consequently can hold the post. Now the retirement is also provided as per the agreement or the nature which he is being appointed. As for the terms of the agreement, he continues his tenure. And this is the very important clause which I want to discuss in the lectures which we are discussing. So what we call as the data of independent directors. Hope this website is visible to all of you. If any company want to appoint independent directors, the website which is provided is, right, the website is that the appointment of the independent directors. Let me see the pen. So the panel is provided, and if we go down, you find very interestingly are the today's data, because there is the data bank or the statistics. What is this data bank? If you see the website, you find it here, total number of directors, right? Total number of directors who is here. right? Total number of directors registered is 20,746, right? The data on ID Bank statistics as on 3rd November 2022, the total number of directors are registered 20,747, and among them there are 5,917 women independent directors. Then companies registered, as we started in the commencement of lectures, as we have seen, every listed public company shall have the 1/3 of the independent directors. So the total number of the companies registered 2,630, and total number of companies made the check in the website is 8,811, and passed online proficiency self-assessment test is the 10,761. This is the data available on 3rd November 2022. That means the existing number of independent directors as for the independent data bank, like blood bank or the group, it is a data where every company can go and search for the availability of the independent directors. If anybody wants, like for example, we can see here one of the name where an aspiring independent director, then you also find share your details, personal qualification, experience, empanelment, official data bank for independent directors, access for online resources, and you feature your profile in the website, learn from the knowledge and resources, and also self-assessment is a milestone. So if anybody wishes to become the part of an independent director, and this is the mechanism which is provided, they enroll themselves, which is provided under the online website or a data, because independent directors data bank is a compulsory document which is provided by the Government of India or the agencies under the Government of India. So where you find board of essential courses, board practice courses, knowledge resources, as well as the newsletters. So this will help you to understand about the what we can call about the data bank and availability of various resources. So I will again repeat, the people who want to become the empanelment or the data bank, so people have to make, that's what the website provides, the data provides, select independent directors from data bank. So this makes a self-explanatory, where a listed public company wishes to appoint independent directors, they can select from a source which is available. That's what we call as from the independent directors bank. So like the bank, then the individuals who wants empanel themselves, they can enroll and get the better knowledge. And if any independent director, either women or other one, who are aspiring, they can register themselves. Then this is how the boardroom they are providing to understand. So under the section 154 onwards are other provisions of the Companies Act, the independent directors are being appointed. So this is the data on November 3rd, 2022. If you are reading the subject at later point of time, then the data may be changes. So you can prepare yourself the data as and when you are watching this video. Now there is also talks another subject, role of independent directors in ensuring high standards of corporate governance. So that is which we don't require immediately, but the data bank which talks about under the Companies Act provisions. So one has to consult the data bank. So I have given the website name, independent director Directors Data Bank. This is the website. So where you will find about the independent directors toll-free number, and the people who want to be empaneled themselves, they can go through the website, they can enrich their knowledge, they can become the part of the independent directors. Now, this is just I explained. Now let me explain about the provisions of Schedule 4 of the Companies Act, which it talks with regard to the Code of Conduct. I will try to explain some of the provisions or some of the code, and some of the code are self-explanatory. The first and foremost guidelines for the professional conduct is that a person who has ethical standards of integrity and probity. Because in the recent days, one of the case which is going on, Young India Private Limited case, the trial is going on in the special courts. This case is also known as National Herald case. So everybody knows the very high profile people are involved. If you see the Young India Private Limited versus Dr. Subramanian Swamy judgment, the High Court of Delhi has initiated or has ordered that the case has to be conducted, an investigation has to be conducted, a trial has to be conducted on the ground that some of the directors have violated the principle of probity. This is the case of the Young India Private Limited versus Dr. S. Subramanian Swamy. And this case is also we call as National Herald judgment. A judgment given by the Delhi High Court, where the High Court has said on the probity, right, on the probity of the directors, there is a need to conduct the special trial. So therefore the trial is being conducted now in the various courts where there is about the violation of the probity by the directors. And other duties, when you look about the professional conduct, that the exercises their duties and responsibilities in the bona fide manner and interest of company, devote the sufficient time, attention to his professional obligations for informed and balanced decision making, right? Devote sufficient time and attention to his professional obligations for informed and balanced decisions. And the ID should not allow extraneous considerations that will vitiate his exercise of objective independent judgment, and he shall not abuse his position for the detriment of the company or its shareholders for the purpose of gaining direct or indirect personal advantage or advantage for any associate persons. Refrain from action that would lose his independence. So like that it goes on, where the independent director is basically given good practices of the human being, good practice of the person with the integrity and the values, where independent director would protect the interest of the company, would also protect the interests of the shareholders. So it brings a principle person having the values and integrity will make the companies proper functioning and possible to deliver its duties as the independent directors. And also the point number 9, assist the company implementing the best corporate practices. So this is what we call it as the guidelines for the professional conduct. And try to remember one point, the guidelines which are given for the independent directors are also becomes part and parcel of law. So section 149 clause number 8 refers to read the code of conduct as well as with regard to the behavior and the duties of the directors. Then the directors shall act independently and also independent judgment, best performances, scrutinize the performance and management of the agreed goals, balance the conflict of interest of the stakeholders, moderate and arbitrate in the interest of company as a whole, in situations of the conflict between management and shareholders' interest, determine appropriate levels of remuneration of executive directors and KMP and the senior management. And this is what they talk about the role and functions of independent directors. Now let us see the duties of independent directors. So when you talk about the duties of independent director, they have to upgrade their skills, and they also should follow the what is called the professional advice and opinion outside the experts at the expenses of the company. Strive to attend all the meetings of the board of directors and board committees which he is a member. Participate constructively and actively in committees of the board. This is very important. A member has to participate constructively. So just coming for a board of meeting for a cup of tea and having samosa and bhaji and leaving will not serve the purpose. Or a board of director attends the meeting just for the sake of the fee will also not serve the purpose. So you should have something called a constructively and actively should participate in the management of the company. That's very, very important. And he should be informed, well informed about the company and external environment in which it operates. So there are duties which are provided under the Schedule 4 of the Companies Act where the independent director should follow, whereas very importantly. Now here I want to take one more important definition. As I told, key managerial persons. Key managerial persons are those people which comes under the section 2 clause 51, right? 2 clause 51, Chief Executive Officer, Company Secretary, Full-time time Director and the CFO. The reason which I am defining about the KMP, when we started our lectures, we started reading that, right? We started reading an independent director should not be in relation to the KMPs or should not be related to the nominee director, and he also should not be related to the key managerial persons, right? So 149 clause number 6 refers the terminology of key managerial person. Therefore, I thought let me discuss on the definition of key managerial person. You can try to connect yourself to the provisions of, right, KMP and independent directors. Otherwise, suddenly you will have a doubt. Why suddenly from independent director we are going to read key managerial persons? So independent director should not have the relation between the KMP. To understand the KMP is defined under the section 2 clause 51, where it has laid down some categories of the people like the CEO, Managing Director, Company Director, Company Secretary, Whole-time Director as well as CFOs. Then there is also another definition that is called Officer in Default. In the case of Officer in Default, which it says Whole-time Director and the KMP, right? And they also says where there is no KMP, such directors are directors specified in the board, and any other directors we have the authority in the board and charged with the responsibility of maintenance, filing and distribution of accounts or records and etc. And also they have the relation with regard to the company, right, where the board of directors have given powers to act in the part or to take in the proper importance of the duties. My point here is that to bring this particular definition, officer in default is the broader definitions. Why we call as officer in default broader definition is that sometimes the independent director also comes in the definition of independent directors. Generally, the understanding is that independent director is a separate person. So therefore, independent director has no liability, right? However, I make a point, independent directors is liable like any other director if he violates the fiduciary duties. So I am bringing a point from the Code of Conduct, Schedule number 4 of the Companies Act, which talks about the duties of the director, where you find, the fiduciary duties that come with such an appointment along with accompanying liabilities. Kindly remember that independent director is also liable to the extent of his liabilities, his fiduciary duties. Nobody can say that I am an independent director, so I am independent from everything, I am not liable. That will not happen. I will repeat again. The independent director cannot take a ground, I am an independent, so therefore I will do whatever I want to do. Then I will try to avoid or I will try to escape from the liability. The purpose is different. So the proviso says very clearly under Schedule number 4, where you talk about the duties of the director, the duties of independent directors have the fiduciary duties which comes with the accompanying liabilities. And he also talks about the directors of independent have code of business ethics that the company expects its directors and employees to follow. That is also very important. So therefore, in that background only, I brought the definition of what is called about the independent directors as well as the key managed persons. So the concluding remarks are that independent director is a separate category of directors, and in the separate category of these independent directors, they are provided certain duties, certain obligations, and also certain privileges under company law. At the same time, they also becomes equally liable to the extent of violation of their duties, that is fiduciary duties, and also the liable to the extent of their liabilities, whatever is given under the Companies Act. So I request to all of you listen carefully. If you have any one of the comments, kindly put the comments in the comment box. I will try to clarify in the next lectures. Thank you for patiently listening. Thank you one and all. Take care. Bye.